When should you create an estate plan? I would suggest that if you're thinking about it, it's probably a good time. Now, as an estate planning and elder law attorney, and when I say elder law, I'm not just talking about serving seniors and retirees. I'm talking about elder law also encompasses serving people who have disabilities. So people, when they're in their 20s, they're not thinking about estate planning unless perhaps they just got married and they have a child, a baby. So they're thinking, I think I'm supposed to do an estate plan. You're absolutely right. You should be. Whereas a single person who's in their 20s is going to say, I'm invincible. I don't need an estate plan. And they might be right until they're wrong, until an accident happens and they are left disabled or some very serious traumatic injury. And since they didn't have durable powers of attorney, they're subject to a court-ordered guardianship, conservatorship, and now the state is in charge of that person. Those are horrible facts, a horrible situation, but they happen. So I do like to, share with people who are younger, having an estate plan, even if you don't have any assets, is important. What's important? Your durable powers of attorney in case of incapacity to keep the state out of your business. Folks who are in their 30s and 40s are perhaps starting to acquire assets, and they probably have minor children or people that they want to pass their assets to. Same thing. They need durable powers of attorney in case of incapacity, so the state is out of their business while they're living. But they also need to have estate planning, typically a will, where they nominate who will be the guardian of the minor children if both parents have passed, where they say where their assets go. Oh, they go to people who are under the age of 18 or even 25 or 30. They go to a trust until that beneficiary has the worldly knowledge enough to manage their money and not waste the money. Next phase where people are typically looking at having an estate plan is those who are approaching retirement or in retirement, and they know without a doubt they need an estate plan, they need their will, they need their durable powers of attorney, they need their healthcare directive. These are folks who, once you retire, you know that at some point it is inevitable you will be passing. It's not something that you can say, oh, that's not going to happen to me. You reach certain ages and you know that that's not something you can ignore. Lastly, for people who are older and facing long-term care, they know that long-term care is incredibly expensive and will deplete or likely deplete their life savings. This is where an elder law attorney comes in and shines. We can do estate planning that will protect half of the assets for the surviving spouse, even in the face of long-term care costs. So when the first spouse dies, that surviving spouse will always have that nest egg, always have these deceased spouses one half. I'm talking in Washington, in Idaho, how our community property laws work, so that the surviving spouse will never become impoverished, even if they have expensive long-term care costs. Also, for elder law firms like ours, ELG Estate Planning, where we have expertise in Medicaid asset preservation strategies, let's say that both spouses are still alive, but one needs expensive long-term care now. There are strategies using Medicaid's rules where we can protect assets so the couple does not need to spend down everything to qualify for Medicaid long-term care. So coming full circle, when does somebody need an estate plan? They need it now.